Hello, everyone. Today we are going to discuss how to sell your house in a probate successfully. Hello, welcome back, and Long. How are you?
Hi, thank you, Long. Thank you for welcoming me back to the show. I'm feeling a little cold, but I'm doing well.
You sound just fine. You sound just fine. Hello, everyone. Welcome back again. This is a 5 year answer in a probate case. If you do have it happening every uh, first Friday of the month. If you do have any question about your specific situation, feel free to send over to us, and we will make sure to discuss that as well. And today, the topic is how to sell your the real estate, the properties in a probate case. Because I heard a lot of people thinking, this is a lot of people thinking that, well, I am the only child of my parents, and now both of my parents passed away. Those properties for sure belong to me, and it's gonna be easy to sell that properties within a second. Is that true, Anlu?
No, that is not true. So I have clients who come to me either when they have found out that their home is the home that is they're supposed to inherit is in foreclosure,
Mm,
or they're trying to sell it and they could not sell it because either their real estate agent or the title company told that they have no authority to sell it.
right, right. Now, briefly talk about foreclosure. Um, it's probably because a lot of people, when the parents pass away and they own a house, right? But they maybe forget about the child or whoever inherits the property, forget about continue making the payment, and therefore when the bank doesn't receive the check in their hands, they have to foreclose on the house, right? And maybe sometimes they are not aware because the bank doesn't have to notify them all the time,
Yeah,
right?
and then when the bank knows about it, they actually have to stop make taking payment too, because it needs to be paid by someone who is authorized to make payment.
Mhm.
So even if you continue to make payment, they cannot accept it.
I see. Interesting. So talk about that authority. What kind of paperwork needed for them to get the power to do all of those?
So the easiest one would be if there was already a beneficiary on the deed itself, then you just you file with the county and you take over title to the house. That's the easiest way to do it. But majority situation fall into probate, where the father and mother they pass away, and the next person in line to get the house is the children, right? But the children hasn't done anything to initiate probate to get that authority. So the house is still in the deceased name, meaning in the name of the parents. And in order to have the authority, they have to initiate probate, and that's
Right.
like going through the court process. Most likely get an attorney involved to file the probate because it is a complicated application. It is a complicated process. I've only known a few people that are able to do it. Majority that have tried to do it have tend to get the application denied, and or cost them money and time, and then they have to come to an attorney and try to do it at that point.
And talk about the beneficiary deed. Sorry, I don't speak the word very well. Beneficiary deed. The I just recently closed on a house. I represent the buyer. The seller unfortunately passed away one day before close.
Oh,
One day before close, like I received a call from the listing agent the day we're supposed to close that, hey, unfortunately the seller passed away. And in that situation, the title company, even the seller already signed the document, the buyer already signed the document, but the title hasn't been transferred yet. Even in that situation, when the seller passed away, title officer cannot close on the house. So luckily, in that situation, the owner has a beneficiary deed, so the deed is actually automatically transferred to three of her children. Now we do have to take some time for the three children to sign the documents to say, yeah, we agree to sell the house and things like that, right? But it's only for like a day or two extra for the people to sign instead of taking a long time in the probate court. So that's a very recent experience as well. So my recommendation is that if you are owning a house and the easiest route to transfer title is beneficiary deed if you don't intend to change anything, right? I guess the second option is living trust, right? Unlo?
Correct.
Mm-hmm.
The second option is live in trust. It's the same thing, kind of similar to the beneficiary deed. If for some reason the original trustee pass away, the successor trustee can take over immediately and start to sign the document the next day.
Mm-hmm. Yeah. So so no, that we cannot. If they have to go through the probate process, right? It's gonna take up to, who knows, depend on the complexity of the case. It can take up to 18 months to complete. I think I remember correctly. You have a case take up to 2 years, right?
Yes.
Before. So it's a very lengthy process, and there is a key document. I call it. Is it a letter of administration for the state of Arizona to authorize that person to become the representative and can sign any legal documents on behalf of the deceased person? Is that right, Will?
So there are two names for it that I commonly use. One is a letter of testamentary, or the other one is called a letter of personal representative.
I see.
Both are essentially the same. It's a letter signed, granted by the court, appointing somebody to be the person representative. Another term for the person representative is the executor. This person gets to step to the shoe of the deceased and then take care of the business for the estate.
Yeah. But to be able to get that document, of course, that person has to file a petition at the court, and then the court gonna look at all the documents, review the proof and evidence, and then approve the representative, right, status. Correct.
That's right, because you never know what the judge is gonna decide. I have a
Right.
case recently where I filed a petition. I asked the judge to allow us to sell the home. The judge decided against it, and he put a restriction on the sale of the house. So at this point, my client cannot sell the house.
Interesting. Can you talk a little bit more about that? Because a lot of people thinking that when they become a representative, right, personal representative, they can just sell anything on their decision. So why is it in this, maybe not too much detail of the case, but at a high level, how can the judge stop, and for what reason?
So in most cases, the judge wouldn't do that. But in this particular case, because there was a minor that is a beneficiary of this estate,
Ah,
and before the judge will grant the power to sell, he needs to make sure that the executor or the person representative, complete the conservatorship and then prove to the judge what he planned to do with the money to protect the minor
right. For
before
the
the judge will allow for the sale.
Got it. Got it. So basically, the idea is that all the properties in the estate has to bring the benefit to the hand, right? To the beneficiary, to the
To the heirs of the state. That's right.
the estate, right? So that is the reason why he wants to stop and then make an extra approval for that sale.
That's correct.
Got it. Got it. Is there any other reason you think that the judge may stop the sale as well?
There was another case, but in that case, I initiated the restriction myself. So the home was in foreclosure, and we have discussed with the bank about giving us time to complete the probate, and then we would sell the house and then pay the loan that is due on the house. However, after working with the banks for so long, for some reason they're very disorganized. We have to call multiple times, send letters and stuff like that, and they refuse to work with us. So what we did was we proceed with the probate and we asked the judge to put a restriction on the home. At that point, the bank is not even allowed to foreclose on the home until they seek permission from the court.
Oh, so a judge can stop foreclosure from the bank. But does that have to involve an attorney, like you're involved all the time, or
Yeah, that case is more complex than normally. I would not recommend an individual trying to do that because obviously the bank can come in with their own attorney and
right,
try to overturn the judge decision if they want to.
right, and I think that is the reason why. I mean, well, the good thing about the American, in my opinion, is that coming from a country like Vietnam, right? Uh, Everything is very detailed at the level that an individual like me can file the petition myself, submit the documents, pay the fee, and get approval by the court, right? But in some situations, like to your point, if it is a complex process, it involves multiple properties, multiple peoples, multiple hands. The best way is to seek out to a professional, a licensed professional, just like you, so that everything is organized and easier and make it successful case, right?
Yeah, because in that case, the bank would not work with the individual herself. And even when they work with us, they were giving us trouble. We had to force them to work with us.
Mm.
And usually, having the attorney behind you can be a very powerful tool because, the implied power that comes with an attorney office, it's individual don't get that.
Right, and most of the time you don't know what you get as well. You don't know the power. Like I said, like a regular wouldn't know that they have the possibility to force the bank to stop foreclosure. Right, they
Mhm.
wouldn't know that. And even if they know, it's still best to seek out to a professional to go through the appropriate channel, appropriate way to do so. Otherwise, it's gonna cause a mess.
Yeah,
If we get in that situation, if we don't stop the foreclosure, the bank gonna become the owner of the house, and the hands will not earn anything. I guess, right?
they'll probably get very little because the bank will take out all their costs and
Mm-hmm.
then they'll reimburse the estate for what's left. But
Mm-hmm.
our goal is to try to get the most amount of money for the estate as possible. And we want to do the sale ourselves and then pay the loan back. That's our goal.
Mm-hmm. Okay, got it. So I do a little bit research on the three ways that a person can sell a property in a probate case. And then correct me if I'm wrong. Number one is a private sale can happen through an attorney office, just like you as well. That's number one. An attorney, because they take care of the case, the office can like sell it to a private market. Number two is it could be on the auction market, right? I mean, if the owner is experienced with the real estate, they can like auction, do it themselves for sale by owner. And of course, the last one is of using a real estate agent to evaluate a house and market the property and sell it to the open market. Those are the three options that I researched. Do you agree, disagree with that?
Yeah, I agree. I
Okay.
would say yes.
Now, with all the respect for the attorney, though, I don't think my personal opinion is that if a person wants to sell the property, seek out to a real estate agent because attorney, even though you guys have all the knowledge about the probate case, selling the property is specifically for an agent, right? Because they have more marketing materials and more appropriate way to sell and make sure that the house get the best benefits as well.
Yeah. So here's what I have to say about that. I don't personally get involved with the sale.
Okay.
Anytime I have a probate case, I always have the client use their own realtor to go through the sale process, and then I deal with the court. Because here's the thing, as an attorney, we're busy enough already to be
Yeah.
dealing with the legal side that we
Mhm.
really don't want to put a foot into the transactional side of things when
Right.
we don't have to. Now,
Right.
if I was a law officer that didn't have clients and I didn't have anything else better to do, then probably that's what I would do. But then
Yeah.
again, my office wouldn't be a very good attorney office if I didn't have clients in the first place.
Exactly. I think that's a good point, right? Because
Uh-huh.
they tried. I mean, those officers they probably tried to get everything that they could, like represent the clients before the church, sell the house, and things like that all together at once. They're probably not good at anything.
Yeah.
I
A good
totally agree.
attorney, I would say, is the one who used a team, who get people to collaborate and help out and get case done as quickly as possible with the
Mhm.
least amount of cost possible.
Right? Yeah, that's totally fair. And same here. For a real estate agent like me, I utilize team as well. For any legal aspect of the probate, I would seek out to Anlung and for advice on that. And how many times that I seek out to you to ask for questions about probate, Anlung?
I would say you call me quite often.
Too many. Too many.
I
Luckily,
need to
that
start. I need to start charging you for my advice.
don't do that. I would be broke by that time. But that's what we should do, right? I mean, we have to lean on each other person, let them know more about the legal side than me. And I probably know more about how to sell a house than Alok, for example. So that's why we partner and we hopefully bring the best benefit for all of our clients.
Trust me, if I was buying a house, I would probably do it through you or another realtor too. I wouldn't do it myself.
Definitely, definitely.
Yeah,
So bring back to the beneficiary deed. That is something that they can set up as they own the house, right? And then it's come into effect immediately when a person pass away. Um, the other way is the living trust, and I think it's more flexible than the beneficiary deed. Can you talk
yeah.
more into that?
So I would only recommend beneficiary deed for very simple cases. If you have one or two child and they're young enough, nothing's gonna happen to them, and there's no real condition that you would have to put on them, then I would use that. But any other situation where you have multiple kids, like a large family, I don't recommend it. Kind of like going back to that case that you have to get the three signature. What if one of them decided I don't want to sign?
Exactly. That's what my buyers were worried about when they heard the news. Like, do have all three of them agree to sign the documents? Yes. Yeah, that's a good point, right? When
Mhm.
nothing happened, when they are all together, when they are all in agreement, right? Beneficiary deed, simple is the best way. But living trust is for if there is a complexity, if multiple properties at once, living trust is the best route to reach that agreement.
Yeah, I had a client recently who had like all their homes. They have several homes, and was
Mhm.
all had beneficiary on it, and I didn't understand why. Because in a situation like that, you would not use the beneficiary deed. You would use the trust instead. Um,
I
but
get
like I said, it comes with the planning. When things get a little more complex, I don't recommend beneficiary deed.
right. I guess a lot of people choose beneficiary deed is because the cost, right? The cost to set up the deed is relatively low compared to a living trust. Has to be
Correct.
true, right? But to your point, if they have multiple properties, right? The amount added up to set up all the deed, beneficiary deed, may be more than the living trust, or it may not even the benefit, the right resource to use. Like for
Yeah.
example, if you want to go to California, right? You can walk, you can ride a bike, you can drive a car, but you have to have the appropriate tool depend on your situation. And in this situation, I think yeah, if they have multiple properties, living trust is the best route.
Exactly. And also, what happened if one of the beneficiary passed away before they inherit the house? That's
Yeah.
also probate too.
Ah. So if that person doesn't have like a living trust or a will, then it's gonna be a big problem, right? For whoever
Exactly.
is your life. Okay. Yeah, yeah, makes sense. Well, I think the time for the show has ended. Thank you so much, everyone, for. Oh, there is actually maybe we can answer this question in the room.
Okay.
Since yeah, there's one question from Jeanette. Since ownership transfers to the children, underwriter has to clear the children in case they have a lien that would take any or all of proceeds. Hmm. This may be one of the comment regarding the example that we talked about at the beginning.
Are you able to paste that question? Because I didn't hear it very well into
Oh,
so I can see what the full question is.
yeah, right here. This is
It's,
the,
it's
the
ownership transfer to children. Underwriter has to clear the children in case they have a lien that would take any or all proceed. Yeah, I mean, if there's a lien in place, that lien needs to be released or paid off.
yeah,
Even though the child can take the ownership to the house, the lien is still on there. So they have to find a way to pay it. They just don't get it outright.
right. Always a lien need to be clear before the remaining of the money go to the owners of the house, either the original owner or the heirs, whoever inherits the properties.
That's the same thing with probate, really. When we go through probate process, we publish a notice in the newspaper for all the creditors to come out. So that means during that time, the lien holder, any creditors, they get to assert their claim. If they fail to assert their claim within a certain amount of time, then they have essentially give up their right to make that claim.
And I think that is one of the reasons why the probate case takes so long to complete, right? Because it has to be published in a certain amount of time. Is that right? Is that how long is it have to be published?
So you have to publish in the newspaper for 3 months.
Oh wow, yep. So that is already 90 days of doing nothing
Yeah.
and
And
waiting for the.
they have like 120 days to assert their claim.
Oh wow.
If they pass 120 days, then they no longer get to do that anymore.
Mhm, mhm. So that is one of the another myth. A lot of people thinking, if anything happen, I just go through a probate case. It should taken care of very quickly. It's not. It's gonna take a very long time. It's like very long time for the appropriate procedure to be done. One
Yeah.
of the example is the publish of to notify all the creditors to come, right?
Yeah.
For the church availability, how well those documents prepare as well, and whether and how soon a church can approve those documents and things like that. So it takes long time. It could take very long time, right?
Yeah.
All right. Well, that is it. That's all the questions that we have for today. Thank you so much, everyone, for watching. If you do have any questions for next show, feel free to send me a direct message. Our next show is our next show is at noon on 7/7. It's a good day. Hopefully to see you again on July 7th. Thank you, everyone.
Thank you, everyone.
Bye bye.
Bye.